Good morning. Happy Wednesday. So today's the big day. Trial of Earl David Warden starts. It's been going on forever now, but today is the big day. Now, one thing that has changed that I've noticed is that Earl filed some sort of a motion for speedy trial. So he is no longer content to waive time. So there is a much higher likelihood that the case will actually go forward today. Much higher. Not guaranteed by any stretch of the imagination, but much higher. The longer the state and or the court procrastinate at this point, the more likely it becomes that Earl will prevail on a motion to dismiss for failure to bring the matter to trial for a speedy trial violation. So that's fun and exciting. Now, yesterday, Chille did a video that I can't find anymore. He did a live stream, and it's not there. But in it, he went on and on about pleas, taking plea bargains, and it's never the right thing to do. And that's kind of a silly thing to say. It is very dependent on the facts in your case as to whether or not you should accept a plea bargain. If the state can prove that you did X crime, it might make sense for you to plead to a lesser crime. Or if it's a situation where the state can guarantee that you get a lighter sentence, it may make sense to you to plea to that lighter sentence. It's only you that can make that decision. And I don't know how many people get a pro bono attorney to represent them, a Harvard-educated pro bono attorney to represent them in a misdemeanor case of stalking. I'm assuming that it is a public defender, and that public defender is on your side. Now, you can disagree with that public defender about the right course of action for you, because ultimately it's your decision whether or not you accept a plea bargain. It is your decision and your decision alone. All that your attorney can do, your public defender attorney, all your attorney can do is recommend a course of action for you. That's all he can do, is recommend it. I did think it was interesting that all the scenarios that our boy DeCastro laid out involved actual crimes being committed, like you going into a store, grabbing a jug of orange juice, getting into a argument with the clerk, drinking the orange juice, and then leaving. Yeah, that's a crime, dude. You thinking you're going to go to trial on a non-crime or on a crime and you're going to prevail? I mean, good luck. If you're entitled to a jury trial, if you get a jury trial, jury nullification is a thing. It does exist. But I wouldn't hang my hat on jury nullification. And for a petty offense like drinking orange juice and walking out of the store, you're most likely going to get a bench trial, i.e. a judge. A judge is going to determine whether or not you are innocent or guilty. And judges don't tend to rely on emotional arguments like the ones that Chille was trying to make. I also want to point out that Chille went on and on and on about his conviction or his plea to stalking. And some of the facts were very interesting to me. They stood out. A lot of times people will tell you certain facts, and they tell them to you so they can explain those facts away. But there's a reason why they're telling you that fact in the first place. Like, for example, he gave, according to Chille, Chille gave the people at the gate a fake name because he didn't want his girlfriend to know that he was coming in. So the explanation is that he didn't want his girlfriend to know he was coming in. But the tidbit of fact he gave was that he gave a fake name. And apparently, the people at the gate didn't have to contact anybody to let them know he was coming in. So why would they have contacted his girlfriend to let his girlfriend know that they were coming in? You know what I mean? Like, that doesn't make sense. It doesn't make sense that he could give a fake name to get in. I have never been on a campus where you have to give a name to get in. I'll be honest about that. But I know of all the places I know of where you have to give a name to get in, like a gated community or something like that, they say, oh, give us your name and tell us who you're here to see. So he gives a justification for the fake name that doesn't make sense. That's issue number one with it. Issue number two with it was that seems to be a relevant fact. Now, why would they want to know his name? Well, maybe because he fit a description of someone who wasn't allowed on campus, because he had been stalking a campus member, someone who lived there. Because, and the facts that he gave, he shows up with flowers. He sees his girlfriend holding someone else's hand. He throws away the flowers and he leaves. And then someone approaches because he was in the women's only dorm area, and he runs. Well, there was another guy in the women's only dorm area, the guy who was holding his girlfriend's hand. None of this is adding up. None of this is adding up. The police, or the girlfriend's, I guess by that point it would be his ex-girlfriend's father, calls the police and wants to press charges on Chille. Number one, how does Chille know that? Number two, it doesn't work that way. It doesn't work that way. Dad's not the victim. And Dad's out of state. So he doesn't have any percipient knowledge. He can't testify as to any of these things. And it's not always exactly easy to get the state to bring charges against someone. It's not always that easy. In fact, I've never seen it easy to the point where a concerned father can call from out of state and get charges filed against someone. Now, a person in in Oregon, these are the Oregon revised statutes, Oregon laws, Oregon revised statutes. A person commits the crime of stalking if, now there are three things, and they're connected by an and. So each one of these three things, each one has to be met. The person knowingly alarms or coerces. Knowingly alarms or coerces. We're going to guess it's alarms. Knowingly alarms another person or a member of that person's immediate family or household by engaging in repeated and unwanted contact with the other person. So Chille would have to meet this first prong. He would have to know that he was no longer welcome with this gal. Not, hey, we just hung up on the phone last night and I love you. But you would have to know that he's not supposed to be contacting this gal. And he has to alarm her. He has to knowingly alarm her by engaging in repeated, that's more than one, unwanted contact with her. It has to be objectively reasonable. That means that from an everyman point of view, from your average reasonable person point of view, it has to be reasonable for the victim to have been alarmed. Objectively. Subjective means that from the victim's point of view, she just has to be alarmed. Objectively means that from a standard of an average person placed in the victim's situation, would the average person have been alarmed? And then, finally, the repeated and unwanted contact causes the victim reasonable apprehension regarding the personal safety of the victim. So again, the repeated and unwanted contact, this is referencing back up here, causes the victim, this is the subjective, so objectively, it has to be reasonable for a person in her position to have been alarmed. And subjectively, she has to be alarmed about her personal safety. She has to have reasonable apprehension about her personal safety. She has to think that Chille's going to come and hurt her or might come hurt her. She has to have apprehension about that and has to be reasonable. Now, there was one other, I don't really remember what it was. It has to be like back when this was relevant to Chille, there was another element that something along the lines of the person had to have no legitimate purpose for doing it. Whatever he was doing had to be done for no legitimate purpose. So that was another element that apparently Chille satisfied, or the DA thought Chille satisfied, in order to bring charges. So none of this makes sense. His Chille's explanation of the situation does not make sense. And finally, Chille was of the opinion that the Ironton case was not terminated. So this was filed yesterday. This is an order. The matter is before the court, so the matter is before the judge, on the magistrate judge's orders to show cause, instructing plaintiff to show cause in writing why, number one, why the motion to dismiss the first amended complaint filed by Lawrence County, Major Chapman, and John Doe should not be construed as unopposed and granted, and two, why the motion for judgment on the pleadings filed by Pam Wagner, Brad Spoljarek, Chance Blankenship, Evan McKnight, Robert Fouch, and the City of Ironton, Ohio, should not be construed as unopposed and granted. Both orders to show cause warn plaintiff that failure to timely comply with this order will result in the pending motion being granted as unopposed for the reasons stated therein. The time to comply with the orders to show cause has passed, and plaintiff did not comply therewith by responding in writing or filing a responsive memorandum to either motion by the given deadline. So the latest one required compliance by November 30, 2022. This order was entered on the 6th. Now that is 6 days after the time to respond had passed. In light of the foregoing, it is hereby ordered that the unopposed motion to dismiss and the motion for judgment on the pleadings are both granted, and this matter is closed and terminated from the court's active docket. It is so ordered, and this is from the judge. This is the judgment. judgment in a civil case. Judgment comes at the end. It is a judgment that is a decision by the court. The action came to trial. Let me make this bigger. This action came to trial or hearing before the court. The issues have been tried or heard, and a decision has been rendered. This is a judgment on the merits. It is ordered and adjudged. The unopposed motions to dismiss and the motion for judgment on the pleadings are granted. The matter is closed and terminated. Now, does it change anything that Chille is pro se? No. In order for Chille to proceed in this case, he is going to have to convince the judge to set aside the judgment. I don't know how he's going to do that. He has been actively filing in other cases, and just I didn't want to file or I was lazy, I don't know, is going to cut it. I am not going to give Chille any advice in this matter. I'm not going to point him in the right direction. But he's going to have to file a motion basically to set aside the judgment. And seeing the way that Chille pleads his motions, his potential for success on getting this judgment set aside are somewhere in the slim to none range. Not saying it can't happen, I'm saying it probably won't happen. Now, as to Chille believing that he can just refile, well, this is a decision on the pleadings. The issues have been tried or heard. So what that means is that those issues are res judicata. The doctrine of claim splitting would preclude any claims that Chille did not bring against these defendants that he had at the time he brought the instant action. So there's two ways that are going to prevent Chille from filing another lawsuit. And by me saying that it would prevent him from filing a lawsuit, what I mean is that he can still file. He absolutely 100% can still file. He can file a lawsuit. He could file any number of lawsuits that he wants to file against Pam Wagner and the city of Ironton et al. But this judgment on the merits is a bar from him ever recovering. And so they can just file a motion to dismiss and say this is res judicata. And the court will look at it. They'll look at their previous order or the judgment, and they'll say, oh, this is res judicata. And they will dismiss the case again. So it's a quick out for Pam Wagner and the city of Ironton et al. Now you're going to say, well, he could just keep doing that. And you're right. He can just keep doing that. But that's how you become a vexatious litigant. It's filing multiple lawsuits that lack merit, i.e., filing lawsuits again after there's been a judgment on the merits. That's the way you become a vexatious litigant. And so eventually, if he does that, if he persists, if he doesn't stop, then the court will be more prone to labeling him a vexatious litigant and putting basically bars in place where Chille would have to submit his complaint to the court first before he'd be allowed to file it, and then the court would make a determination on whether or not the complaint has merit before they allowed him to proceed, serve the other party, do all the other fun stuff, etc. So anyway, I hope you found that informational. As far as the impending trial of Earl Warden, I do hope, my most fervent hope is that Earl is found not guilty because he didn't actually molest his daughter. That's my hope. If he did molest his daughter, obviously I want him to face the maximum punishment for it, because that kind of behavior can't be tolerated in a civilized society. So anyway, good luck to you, Mr. Warden. If you are innocent, I hope you're found not guilty. Thanks for watching. Have a great day.